It's not unusual in elder law to have a client and their family with the following scenario. Mom's a widow in declining health, but still competent. The family wants to keep her at home when the time comes. Mom doesn't want to go to a nursing home, and her 2 daughters want to be able to keep her at home. Joy and Martha. Joy is married, works, and has 2 kids, one nearing high school, so college is not far off. She can't stop working to help Mom. Martha, not married, no children, is willing to move in with Mom to take care of her when the time comes, so she doesn't need to go to a nursing home. The question that everyone asks is this: in this situation, is there any way that Mom can pay Martha since she can't work if she takes care of Mom? The good news is that if drafted properly and followed through carefully with the terms of the agreement, a caregiver contract can work so that if Mom needed to eventually move to a nursing home, the payments to Martha will not be treated as gifts. Often, the family will come in after the child has already been providing care to the parent. In that situation, the child can't be paid for those services. The agreement can't be made retroactively for services already provided. Without a contractual agreement, MassHealth will consider that the child has taken care of the parent out of love or kindness, as this is what families do for each other. Any payments made without a written agreement will be considered gifts if a nursing home is needed, and a penalty will be incurred, during which time Mom will have to pay privately for her care. Can an agreement be made for services provided going forward, even if Mom lacks the capacity to contract? Yes, so long as Mom has signed a durable power of attorney granting the appropriate authority to enter the contract. Having the care agreement is no guarantee that you will receive MassHealth approval, because there are many traps for the unwary, both in drafting the agreement and then in the caregiver following the terms. Meticulous record keeping is required. Although the personal care agreement is most often between a child and parent, it could be with any family member. The agreement itemizes the services or tasks to be provided and the compensation to be received. A lump sum payment made upfront will typically not work. There are other programs to compensate an individual for caregiving. A personal care agreement has 3 basic requirements for a person to pay a family member for care. The agreement must be in writing. The payment must be for care provided in the future, not for services already performed. And compensation for the care must be reasonable. This means it should not be more than what would be paid to a third party for the same care in your state or geographic area. Tasks performed should match reasonable or customary fees typically charged for these services. If the person receiving care needs to enter a facility or apply for other services that Medicaid might pay for, the personal care agreement can show that care payments were a legitimate expense and not an attempt to hide assets by giving cash to family members. The person receiving the care is paying for the value of personal care services.